thank you everyone for coming to this webinar today. You know, of the many components that come together to make AOT programs effective, I'd say by far the hardest to pin down and define precisely is that funny thing that we call the black robe effect. You know, so often when people think they understand AOT better than they do, or are convinced that it just can't work in their state, and we get pushback from the advocacy that we do, people will say to us, well, this can't work here because I've looked at this AOT law we have and has no teeth. As if in all the places where AOT is working brilliantly and saving lives, as if the laws there were empowering judges to deal harshly with the folks who violate their court orders, and you know, as if participants in those places were all kind of scared into submission, and that's why they were following their orders. And of course, all of you with us today as members of our AOT Learning Network know that that's nonsense, that in fact, judges are relying on a much softer form of power to help people make different choices in their lives and alter their behavior. Really, in every state, there's no place where we're working with state laws that you know, have a lot of teeth to them, where people can be in trouble for not adhering to their AOT court order. So today, we'd really like to take a deep dive into how judges really do it. And for that, we have assembled this really wonderful panel of AOT judges from across the country that we at TAC have enjoyed working with over the years and getting to know. And one of the things we really strive for in putting this panel together, which wasn't easy because, you know, we have such a deep bench, no pun intended, of great AOT judges that we work with. Many of the people I think who are attending today in the audience are folks we had really wanted to squeeze onto this panel, but we wanted to make sure we had different kinds of jurisdictions represented, big cities, small towns, judges who've been doing it a long time, judges who just started doing it pretty recently, programs that have been funded by SAMHSA and programs that have not. And, you know, hopefully we'll have a couple more judges join us soon that are going to help us check a few more of those boxes. But I think probably a good place to start is to just have each of the three judges who have joined us today to just kind of introduce themselves, take a minute to say how long their AOT program has been around, how long they personally have been involved, and how large a program it is, how large their docket is. So why don't we start with Judge Anderson?
Good afternoon. So I'm in Nevada County, California, which is in Northern California between Sacramento and Lake Tahoe. We've had AOT court going since 2008. I've been the presiding judge during that entire time so far. And we average approximately 5 to 6 new orders per year. We're a small county of approximately 100,000 population. So that's consistent with the national average, I think. Currently, we have about 7, 8 people under order. Some of those are carryovers from previous year. In California, there's a 6-month limit on an AOT order, but we've had people who have extended, which makes up the difference.
Great, thank you. So that's kind of our small end of the spectrum covered in terms of you know, size of jurisdiction. And from a big city, let's introduce Judge Reese from New Orleans.
Good afternoon, everyone. Thank you, Brian, for inviting me to be part of this discussion. Our AOT program has been in effect. Well, actually, the law has been on the books since 2008, but it was kind of laying fallow for a long time. My good friend and yours, Janet Hayes, brought it to my attention in, I dare say, about 2017, and we started having stakeholder discussions with folks in the mental health community and decided that we needed to really implement this law. We started receiving cases in December of 2018, and we've probably had about 75 to 100 referrals. We've had maybe 25 to 30 orders for petitions filed. And we've had participants vary with that. We've had some folks to go entirely through the program. And when it works, I have to say it works incredibly well. the individuals that graduated after about 18 months of participation, our AOT audits last for about a year. And we extended them because we had yet another hurricane, and that warranted extending it to kind of get them through it. And then the pandemic kicked in, and that had an effect as well. But, you know, the folks who graduated are doing incredibly well now. They're still stable. They're employed. Matter of fact, one of them has opened his own business, and it really is very gratifying to see that.
Yep.
Now, you know, we've had varying levels of success, and you have to realize that, you know, you're not going to save everybody, but the ones that have participated and utilized the program, it's been very beneficial.
Fantastic. Thank you so much. And let's turn to Magistrate Hyder from Ohio.
Yes, good afternoon. Full disclosure, I'm a magistrate in Ohio, or I recently retired. And magistrates are appointed by judges. They're not elected in Ohio. But I sat on the bench and did the civil commitment hearings for about 18 years. And I was part of the court system in Butler County for about 20 years. The population of Butler County is about 390 to 400,000. We would carry a caseload of anywhere from 80 to 100 cases a year. And some of those cases had continued. In fact, there were individuals that were civilly committed the entire time that I was on the bench, the entire 18 years. So as some cases would fall off and be dismissed, other cases would be added, but the caseload itself stayed around 100 individuals.
Gotcha. Thanks so much. And I see we have been joined by Associate Judge Parsons from Harris County. Judge, would you please just say a little bit about your AOT program, how long it's been around, how long you've been involved, and about what size of the program you've got running right now?
Okay. I apologize for the delay. I was stuck in a docket prep that I couldn't get out of. So
Understood.
I apologize. Okay. So yeah, so I'm in Harris County, Texas, and this is a relatively new program. We tried to do this several years ago, and it didn't work for 50,000 reasons. And we've restarted it about a year and a half ago officially, but then we got the SAMHSA grant. So I think our grant was we're about a year into the grant, I think. And so let's see, I think we've served to date around 60 or so patients. Currently, our current docket is around, I think, 20. We're right at 29. We're about to hit 30 of ongoing, but total served is around 60-ish. And what else did you ask me to do? I'm sorry.
No, I think you covered my initial question. So thank you so much for that.
All right.
And so I think Judge Parsons is the only judge representing a SAMHSA funded program today. The others are all from places where it was kind of built without any kind of federal support from scratch. And maybe we can get into that a little bit as well today. But we're hoping at some point to be joined by Judge Liu from Reno, who also was a SAMHSA grantee. So let me get into my first round of questions. And let me just say before I start that, I really want this to be a conversation. So, rather than even having to wait for you to be called on, if there's something that you hear another judge say that you want to react to or respond to or amplify, by all means, just jump in and let's try and make this as conversational as we can. But let me start going back to Judge Anderson and ask you, what is your basic view of your role as the judge in motivating AOT participants to stay engaged with treatment? How do you see that role in relation to what the treatment team does, which obviously is working with the person much more intensely on a much more regular, if not daily basis?
I mean, of course, it starts with making sure they're aware of their due process rights, making sure they have counsel and covering that. But in terms of relating with the participant, really my focus is on just trying to sort of engage them by letting them know we accept them sort of as they are, that they have a voice in this whole process, that it's not criminal, and really emphasize that they have a significant role in this whole process. We're just not here to tell them what to do. And we spend a lot of time on that. When we first discuss the proposed treatment plan with them, we sort of keep it open to possible negotiations. And if they're willing to do 4 things, but they're not willing to take their meds, we have a discussion about that. I ask them to keep an open mind and talk with the doc. But otherwise, we delete that requirement from the court order and have them sign it. And at the same time, we have the treatment providers sign that they're going to provide the treatment. And we make a big deal out of that mutual signing to show that they are empowered, that if they show up for a meeting and the treatment provider isn't there, we're going to hold the treatment provider accountable. So we try to give them a sense of participation and hope that that carries through. Oftentimes, it doesn't seem to make a difference in the first few weeks or months of their involvement, but it grows. And then once we get them engaged, then the discussions about medication seem to be more fruitful after they've become engaged in acceptance of services. So what I find is that by I stay on the bench. I don't go down, like I know some courts have a real much more informal process to sort of emphasize that mutuality. I stay on the bench, but I try to engage them in conversation with just that idea of, engagement, acceptance, encouragement, and always find that something they're doing is positive. And the result of that seems to be that then I'm not directing their care, but I'm sort of just overseeing that they're getting what they're supposed to be getting in support of them. And so I still have the judicial role of being in control of everybody's, more or less, but it's seen more supportive than directive.
Yeah, thank you. That's really interesting. Especially, the part where you mentioned that you see people tend to come around a little bit, that they may be, not really letting the program in at
Right.
first, be more standoffish, and then they kind of come to be more trusting and accepting. Do you think that's really just about the fact that the treatment is working and they're coming to trust the team more? Or are you also seeing that in their interactions with you, that they come to be more trusting of you as someone who's on their side rather than someone who's there to, give them a hard time?
Well, obviously, it's a bit of both, because without the success of the treatment providers, but it seems for the most part that their suspicions about being involved in that process are eased a bit when they think the court is supportive of them and not just being, strict supervisor of them. And I think that makes a big difference. For those that are seem to be doing well, I always remind them that, the AOT court, when I have that calendar, it's my good news day. And they're part of my good news day, unlike the other courts and the other experiences in the court system. So I really look forward to seeing them, especially in hearing that they're doing well. And that seems to hit a chord.
Yeah. Magistrate Hyder, as the other member of this panel who has been involved in this for quite a long time, does that description of the role of the judge resonate with you? Is that pretty much how you would describe how you see yourself and what your part to play is in getting the person to be motivated to engage?
Yeah, definitely. I think I added it up at one point, and it was somewhere between 4,000 and 5,000 hearings that I had presided over during the course of this 18 years. And the program had actually been in existence maybe 25 to 30 years, so longer than my tenure. But the beginning was definitely a shaky start, and I'm sure we'll get to some of those issues as to what shaky start means in the beginning. And I didn't get to mention that's Hamilton behind me, by the way. That's the county seat in Butler County, Ohio, and the building that's sticking up right here is the courthouse with the green top on it there and the clock. That's the courthouse.
Nice.
Back in the thing. So that's.
Is that your real view out your window, or?
Yeah, no, this is the power of Zoom. If I move too fast, my head will disappear. One of the things that did resonate with me was when Judge Anderson mentioned that you accept people where they are. And that I really see that as critical, is that this isn't a judgmental type of thing. And, once you get past the initial hearing, I really tried, very hard not to make any judgments about where people were. And I'll get, for an example, if somebody decides that they're going to smoke a bunch of marijuana and they're a little bit in the weeds in terms of their treatment plan is going and they're getting that off the street, our discussions would center really around personal choice. That once somebody's on their medication and they're stabilized and they can reason with you and hold a conversation with you, I firmly believe that your life is made up of a bunch of very small little personal choices, which all end up strung together. So where you end up has to do with the path that you put yourself on. And that would be the kind of conversation that I would have with somebody. I didn't see myself in a position of saying, you definitely need to stop doing that. You shouldn't be doing that. That's the treatment team people's job. My job was to remind them that, just as Judge Anderson said, that they have a role in this process. They're participating in it. I'm participating in it, and we're kind of working together and giving back people the personal choice. So if you make a whole series of bad personal choices, your treatment may not work out too good the rest of your life. Your life just doesn't happen to you by chance. You are involved in making it. And sometimes the people that end up in your court have never had that conversation with anybody and never looked upon their lives that way before. Especially if you've had the burden of this illness and you've been carrying this illness for many, many years. You think things are being done to you. You don't see yourself as somebody empowered to make choices. So the personal relationships, especially in my case, because some of our cases were so long going, were extremely important. And I do want to mention my tool for maintaining those personal relationships. And that was, we called it the Red Book, just because it was kind of red hot and it was, in the beginning, very confidential. It was considered an attorney-client work product, so in our court. So I was able to get very graphic in terms of the kind of notes that I kept about people and their families and whatnot, just to jog my own memory and know where people were. And I just kept it in a Word document that ultimately I had to divide according to years because it got so huge it became unmanageable on the server. But it allowed me to pick up from where I left off, because I only saw my cases every 6 months, sometimes every 3 months. So 6 months can be a long time, but I could pick up where I left off and know exactly what I had said to them, what they said to me, what we plan to talk about next time without, and my example is always my hairdresser. Love her to death, been going in the same place. And she always asked me what side I part my hair on. I mean, seriously, really? You can't remember what side I part my hair on. So, I never wanted to come across like my hairdresser. I wanted to remember their mother's name, their dad's name, when their dog died, what their roommate's name was. I wanted to remember everything about them so we could pick up on this very personal, intimate place. And that's all about gaining the trust. Because if they trusted me, then they were going to trust all the members of the team, and that was going to contribute to them participating in their treatment plan.
Yeah, that's a beautiful thing. And I'm sure you impressed many participants with your extraordinary memory.
Yeah, exactly. Exactly.
Judge Reese or Judge Parsons, would you like to add anything on this point of the basic role of the judge as you envision it in making this program work?
Yeah, well, let me say, Magistrate Hyder, it's very important to know what side your hair is parted on. You don't want to mess that up. Absolutely. No, yeah, my experience has been, and we had a lot of referrals from our local medical center. And people had usually, initially at least, folks had been hospitalized, they had been stabilized, and they were pretty much in probably the best position they could be in. And I found that to be really an optimum situation. It's not always the situation, and that's not always the ideal, or it's not always in that posture. But, I wanted to approach them in the Black Robe effect. I wanted them, first time I met with them, I would have the robe on, literally, and say to you, listen, you're out of the hospital now. You're in a stable situation. We want to keep you there. We don't want you to have to go through this merry-go-round that you've been going through, because in the Louisiana statute, one of the criteria was that you had to have been hospitalized a number of times within the last 36 months. That has since been changed, but at the time, at the outset, that's what it was. And, you know, my job is not to put you back in the hospital, nor is it to incarcerate you. My job is to, and you say, establish the rapport, to keep you in as stable a situation and as comfortable a situation as we can. Now, I'm part of this, but you're part of this. And you have to establish that rapport. And like I say, my predecessor said, you have to build that trust that I'm a stakeholder in your well-being. And we're all determined, all the members of the team are determined to put you in the most comfortable position. I also open the door if you have a problem with the regimen, with the treatment order, you need to let me know. And then I can speak to all of the other participants to see how possibly it might need to be amended to make it more comfortable for you so that it works for you. And, you know, how much success we have is largely incumbent upon you, because you have to maintain the regimen. And ultimately, all of this is for your benefit. And if it doesn't work out, you know, it's because, you know, we may have some issues, but if you have issues, that really is one of the biggest problems we could have. And try to keep that rapport going throughout the course. And if you can maintain that, then you can have that measure of success.
Terrific. Thank you. And, you know, I neglected to mention, I think, in my introduction, that I'm going to hope to open the floor to questions from the attendees. Of course, we can't have you speak because of the nature of the event. We you know, it's not open in that way. But if you put questions in the chat box, I would love to be able to ask whatever you might want to ask of these judges about how they view the role of a judge in making AOT work. So let me turn to Judge Parsons and talk about the practice of checking in with people during the period of the order, because Magistrate Heyer mentioned already that's not something that was part of the model. Some programs do it, others don't. I know yours does in Houston. So can you just talk a little about what you try to accomplish at those check-ins in terms of, you know, helping a person make progress from one to the next, and also how you get the information you need from the treatment team to know what each person at the check-in needs to hear from you, so that you can be most effective in making that work?
Right. So, Judge Heyer, I think I heard you mention that you had a book that you kept all of the latest and greatest information about each patient, right? And so I'm blessed to have staff that does that for me. So they keep notes about what happens during the status conferences. We call them status conferences with the court. And that way, so the next time I see them, that I have a little summary of, you know, what we talked about last time, what were issues that were outstanding, what are something maybe we can touch base on. And so I think that's really important, because it lets them know that you remembered what side their hair was parted on, and that's important. And those little things do matter. And when we do those first meet and greets, you know, I let them know, listen, we're all here to support you, but you have to do your part, right? I try to make sure that that's something that they understand. But at the same time, you know, let them know, listen, we're here, we're going to get to know each other, and let them know that it's a place that they can tell me anything that they want, good or bad, it doesn't matter. And some days I regret that, but I let them know that, and that, you know, as long as they don't lie to me, right? They just have to be truthful, and they can tell me anything they need to, anything they want, and we'll just deal with it. And so during those status conferences, we kind of use it we just chat about all the good things that have been going on, all the bad things, all the things that they've been struggling with, or, you know, whatever it may be. And so the case managers, I've always said this from the beginning, that the case manager piece of it is really makes or breaks the program. I mean, the court, we're here to support. I view it as a support for them. So if they're struggling with something with the patient, they're like, hey, judge, you know, this patient's really been struggling with X, Y, and Z. Could you help kind of be a little bit more of an enforcer with this particular piece? It would help us, right? And so the staff, the case management staff, sends an update every week to the court so that we know what's been going on from their perspective. And then I have my summary from the staff when we talked about what we talked about last time, and try to use both of those notes during the status conference when we speak. And I think that they, you know, it depends on the person, right? Everybody has a different personality. And like you said, you start where the client is. That speaks to my social worker heart. I was a social worker also before I was a lawyer. And so that is, you got to start where they are. You got to figure out what makes them tick, what makes them respond, what doesn't work for them. Because what will work and make someone respond for one person will not work for your next person. And so it just really, you just start to get to know them and figure out what seems to speak to them. And, you know, I've had some patients where, you know, we start out and it's like pulling teeth. You know, I'm asking, I start with open-ended questions and I have to drill down to specific questions and I get one-word answers, right? And then 3 weeks later, the same person is asking me what I did for the weekend, right? So, you know, it's just this evolution that starts. And I think, again, that case management piece is so important. You've got to have great case managers. You've got to have a lot of really good wraparound services that go with it. And honestly, sometimes it's just as simple as, you know, for the patients to know that, for the patients to know that the court is there to support them. But I think Judge Anderson mentioned it. It's not just to help make sure that the patient's doing what they're supposed to, but to help make sure that they understand that we're there to make sure that the staff and their treatment team is doing what they're supposed to. And that, in several cases, has created a quick rapport with the court when the patient's like, oh, hey, they have my back. I had a complaint because so-and-so didn't get me what I asked for. And then the court made it happen. So now I'm willing to come to the court, right? So all of these little tiny pieces, just a drop at a time, really can make such a big difference over time. I mean, some people, no matter what you do, you may not get there, but it's been fascinating for me to see such a transition from people who are just fighting you tooth and nail. So the next thing you know, they're, you know, wanting to chat about, you know, what you did on the weekend. So,
yeah, that's really cool. And I would imagine doing the check-ins or the status conferences periodically as you do them, you're really seeing that progression, right, from one time to the next in a more gradual way than I guess Magistrate Hyder would be able to see it, where maybe the change is more like overnight. so it would seem, because you haven't seen the person in 6 months, and I'm sure the differences are more dramatic.
Well, so one of the, I would say mistakes, but it was a learning opportunity that we went through was, you know, we really were in the impression that, okay, listen, we got to like be on top of these people, make sure that, you know, they're getting everything that they need, that they're staying on top of their treatment, et cetera, et cetera. And then Brian came in and said, wait, that's kind of a lot. Like, maybe you're suffocating them. And I was like, what do you mean? No, we're making sure that we don't get lost through the cracks. And he said, yeah, I know, but sometimes less is more. And so he was so right, because we were able to see that some people who were fighting us tooth and nail, and the minute we started having status conferences like frequently, they were so much better, right? They just were tired of us being in their face all the time. And they're still with us and they're doing really well. And they've been so much more compliant and not fighting us all the time. And so that was the learning opportunity for us. And that was big. And I think that, but on the flip side, there are some people that we were like, okay, well, you know, you've been doing really well. You don't need to come and see us as often. And they were like, no, I need the structure. I want to come see you. Also, I like to make sure that, you know, you make sure things happen, right? So we've seen both. So that's been really interesting.
Right. And it doesn't have to be one size fits all. You know, you can see some people more often than others. Some people might actually benefit from the incentive of, you don't have to come in as often. You can use that as kind of a carrot.
And our program we've been really good. We're lucky that we have a lot of resources within them. And so a lot of these people are just haven't had basic things, like they don't have an ID, right? So the case manager is able to get those things for them and make sure that they have toiletries, and make sure that, you know, just some of the basic things that cause their life to be chaotic. Once we're able to provide those things for them, everything else seems to, you know, snowball into a better direction.
Right. Right. And, you know, this actually relates to one of the questions we've gotten here I see in the comment field about what's the ideal interval between check-ins. You know, as we've said, I think it's pretty fair to say that it's not going to be a one size fits all, but as a general rule, and I'd open this up to any of the judges who do check-ins, what's your sense about what's typically the right amount of time to go between visits with a person? Judge, you want to take that?
I'll jump
in.
Yeah. Go ahead.
Go ahead, Judge. No, go ahead, Judge Andrews.
Okay.
We'll do it in
well,
alphabetical order. Start with
When
A.
we have a new participant, the first status review is never more than 2 weeks out. If they are having difficulty as we go through the process, we usually sometimes we shorten it to 1 week for status reviews. Otherwise, it generally ends up being about 3 weeks as they progress and are seem pretty stable. And in some instances, it's further, as you pointed out, it depends upon the individual. For some, it's more traumatic to come to court than it is to go to their sessions and their therapies. So we rely just on a report from the treatment provider and don't require them to come into court necessarily. Zoom has helped with that, of course, being able to make virtual appearances. It takes some stress off some folks, but some, I feel, we get a better interaction if they're actually in the courtroom. So, but it does vary.
Yep. Judge Reese?
Yeah, our statute calls for, after the petition is filed, we have to get them in the court within 18 days. So I set my AOT hearings usually every 2 weeks. The statute got amended and Brian had a substantial hand in helping us amend our statute this past legislative session. And now, before the person had to have the results of an examination prior to, at the time they filed their petition, now they can file the petition and we can send them to be evaluated. And that comes in. You get a feel for the individual. And initially, maybe every 2 weeks that we have court, they come in for status just to make sure they're picking up the regimen and then they're adhering to the treatment order. With the passage of time, and maybe after about a month or 2 or 3 months, then if they are picking up and staying with the process, then we can go to monthly. And as they progress and maintain, and after about, I would say 6 months, if they're doing very well, you can bring them in quarterly. And just, you get to the point where if they have successfully gone through the program, stayed with the regimen, stayed in the medication, and adhered to all the points in the treatment order, then, like I say, once a quarter, maybe give them 6 months, tell them to check back in just to make sure you're doing fine, and then they can graduate. So, it kind of depends on the individual. As they say, every court rises and falls on its own merits. Every case you have to kind of judge it based upon the kind of success or lack thereof that you're having. And that's kind of how we play it.
Terrific. And I see we have a question from a judge who's just about to get started with getting an AOT program launched about who takes part in those check-ins. She's asking who attends. Do the members of the treatment team attend? If the person has a guardian, are they going to be there? I know we often have questions about whether counsel need to be there for, what are often considered informal check-ins. What's the practice with each of the three of you who do check-ins?
I'll start with that.
Okay.
I did want to comment that the 6 months hearings that I talked about, those were evidentiary hearings that were kind of a
Right.
check-in evidentiary hearing all wound into one. So at that hearing, there'd always be counsel for the respondent. If they had a guardian, the guardian would be there. Service providers, that might depend on, they wouldn't have directly gotten notice from the court, but they might have been invited maybe by the guardian or even by the respondent, him or herself. If there were cases that I needed to see more often, those would be the informal check-ins that I think we're all discussing here. And they would be very informal. There'd always be attorney for the respondent there. We never had a respondent in court without being represented by counsel, because you just don't know what's going to happen, and what you thought was one kind of hearing can turn into something very different when you get in the courtroom. So they were always represented by counsel. But that might, the prosecutor would always be there also. So as Judge Reese said, I would have cases where our general docket was every 6 months, but there might be a case that I'm seeing every 3 months, or if there's a problem, I might be following it every month. And I'll give you an example. If I found out that one of our mentally ill people was living in an environment with bed bugs, I was on that case until that person was moved, the environment was cleaned up. And so I kept resetting that. I didn't reset it because I needed to bring the mentally ill people in. I reset it because I wanted to get everybody else to their attention. I wanted the service providers, the case managers to understand that I was deadly serious, that we don't allow mentally ill people to live in places with bed bugs. So there might be a lot of reasons why you set a case more often and monitor a case more often.
Yeah, and that whole issue of the black robe effect upon the treatment system itself is a really interesting one, and maybe something we'll get into in a little more depth.
I didn't mention it. I think everybody else did, but I wore my robe and stayed on the bench. There's a lot of cases, especially in guardianships, when I was dealing with the elderly, where I might step off the bench and go down to the table where they were at and sit kind of eyeball to eyeball with them. But I didn't feel I really needed to do that in most of our civil commitment cases. I stayed on the bench and kept my robe on. But, Judge Parsons said it, sometimes that you're showing that you're on the side of the mentally ill person because you're really, kind of coming down on everybody else, not them, but, you're enforcing what is in their best interest.
Right. And I guess it's fair to say there's almost a little bit of a performative aspect to that too, right? Because you want to communicate you want to show the person that you're fighting for them.
No. Usually when I was trying to show them that, I was dead serious about something. There was something
Yeah.
had really ticked me off for some reason in the way that they were being treated or way something was being handled. And I'll give you another example, is that if somebody is living in an environment where they are having too many, let's say, for example, that you have somebody that has fantasies about touching children. That's an issue. It's part of the makeup of their hallucinations, and they're in an environment where they see a lot of children. That's not good. That's not good. And the fact that I can't find anywhere else for them to live, this is the only place that works right now. Those aren't, work harder, find another place. I mean, that's not an excuse. So I think really listening to what's happening in a case and being kind of this devil's advocate, sometimes, our program ran really well because we had a probate monitor. And I've been in enough of the Treatment Advocacy Center panels now that I understand that a lot of locales have probate monitors, but somebody has to be on the ground kind of, keeping track as a liaison between the court and the treatment providers and the case managers and kind of getting all of that running. But nonetheless, even if everybody's doing the best they possibly can, a lot of those folks are so close to it, and they're so overloaded with so many cases that it takes another voice to say, no, let's step back a little and take another look at this case. This person needs to live in a different environment, and I think that's another role of the court, this kind of independent observer that can, just shed another pair of eyes on things.
Absolutely. And it makes me sorry Judge Liu is not able to get away from her case to join us, because she in Reno, she deals with that so often, with the fact they want to stick people in these really terrible SROs they have there. And so much of what she's been able to accomplish is to just kind of really stand up when she sees people being placed in deplorable conditions.
Yeah, sometimes there were cases where I would push and push and push and push, and I really saw that was my job. That was what I was supposed to be doing.
Yep. How about the issue of whether counsel needs to be present for check-ins? I'm not sure if any of our judges here today work this way, but there certainly are courts where the check-ins are just really considered very informal. Hey, how's it going? How you doing? There's a concerted effort not to take any kind of legal action on the case in those meetings. And so there is a feeling that there is not a need to have counsel present. Other jurisdictions.
Brian, if I could chime in on that.
Yeah, please. Yeah.
We have civil commitment hearings every Thursday here at Civil District Court. And the Mental Health Advocacy Center here in New Orleans would represent the folks coming before the court on civil commitments. So I spoke to the staff folks at the Mental Health Advocacy Center and said, I'd like to schedule my AOT hearings the same day as your civil commitment hearings. And that way you'll already be at the courthouse. And I just schedule my hearings. They usually do those in the afternoons at 1 o'clock. So I scheduled my AOT hearings at 11 so that they could be present to represent the participants. Because sometimes in the status hearing, an issue will come up like the medication regimen isn't working and we might need to amend the treatment plan. Well, before I take any action that has to be put on the record and may result in a ruling, obviously you want to have that representation there. And that's kind of how we deal with it. So there's technically always representation available for the participant, even at a status conference. That's how we resolve it.
We do the same thing. At our status conferences, we have the representative of the treatment provider, county counsel, and the public defender, who represents most of the participants, present along with the participant for just the reasons that Judge Reese stated. But there's another benefit that really goes along with that, is when the attorneys are there for the original petition and go through that whole due process performance, then they're there at the status proceedings. They see the improvement, they see the changes in the individual, and that causes them to buy into the whole process and the reasons why we have AOT. And they spread that knowledge to their, to their cohorts back in their office, that this is, they come out of this really brief court session feeling good, And that's really important for the long haul of the program, to have that buy-in, that experience. One other side note is usually the case manager is present also, because most of the time they're the person bringing the client to the court hearing, but they don't talk at the status hearings. Any information they had about what's happening with the client, they tell to the representative, which is usually their supervisor, who sits at the table, at council table with county counsel, and they tell us in their report what the concerns are, what's been going on. And we do that intentionally so that we always keep the relationship between the case manager and the client is very personal and independent. So any bad news or problems that rise come from their supervisor to the court, not directly from the.
Right, to not interfere with that therapeutic bond.
Right.
Yeah, that's pretty interesting. So, we've talked a lot about the need to have the patient come to think of you as a friend, as someone who's on their side, who's going to be their champion. We've also talked about the need to sometimes come down a little bit harder on the treatment team folks when you feel like people are not getting what they deserve. I wonder if any of you can speak to whether there are situations and moments that you can recall where you've had to flip the script a little bit and maybe come down. You just felt like the situation called for coming down a little bit harder, being a little bit sterner or more severe in your tone, or more like a, parental in your tone with someone who was just not engaging in the way you had hoped.
Well, yeah, that happens kind of routinely with some folks, because, most of the clients in mental health court and in AOT courts are pretty intelligent folks, and they can be very stubborn and insistent upon their own self-education is the right answer to questions. And so sometimes you have to sort of accept the challenge and just go at them and say, no, I've read the sites I've read those websites that you referred to, and they're bogus, and deal with them straight up. And I think, and you have to deal with them straight up, because all these folks are really keen on BS detectors. So
Yeah. Is this like anti-medication websites that they may have?
yeah.
Yeah. Interesting.
Yeah, periodically, matter of fact, I had a young woman recently. At the first hearing, she was asking me, well, how long am I going to have to be in this? And that was a trigger to me. Well, this doesn't look like it's going to go well. And needless to say, after the first hearing, we heard that she left the state, and, had gotten in some trouble in the state that she had gone to. Then, incredibly, about a month or so later, she was back in Louisiana, and we had her back. And I talked to her and I said, this is for your benefit. I mean, if you accept it, you can, your life will have a better quality. You're now on another judicial commitment. You're back in the hospital. Don't know how long you're going to be hospitalized. And participating AOT potentially can keep you out of that situation. But, obviously you have to buy into it. And I talked to her for a long time. And at the end of it, she says, I don't want to be a part of it. And I kind of went back at her a little bit more. I said, I'm not going to incarcerate you. That's not part of this process. But the other side of the equation is that I'm sure you don't enjoy being in the hospital where you are basically can't come and go as you please. If you participate in AOT, you may have a better opportunity to have a better quality of life from your perspective. But if you choose not to, then, there's nothing that I can do to assist you. There's no benefits or no services that I can bring to the fore to help you progress. But if that's your choice, that's your choice. Well, she chose not to. So, at some point, and to say you have to have the realization that everybody is not going to be part and parcel or not going to buy in, not going to be accepting. And it has to be a situation like any other treatment regimen that the person has to accept where they are, what they have, and they don't want to live like that anymore, and they want to improve it. Once they get to that point, then AOT can be very effective.
Yeah. So that didn't work out too well for that particular young woman, I guess, huh? Yeah, I do think that's something that anyone venturing into this area needs to accept and understand up front. You're not going to save everybody. This doesn't always work. We had a question in the chat box from a mother who I know is really dealing with a very challenging son who just insists that he does not want to take medication. She's asking, well, what do you do about a person who simply says, I'm not taking my meds, and, challenges you to do anything about it? And I think Judge Reese has kind of addressed that with a similar situation. Does anyone else want to speak to a situation they've dealt with where it's just a really difficult case and you kind of felt the limits of your power to do anything to motivate?
We've had a case that he started out actually sweet as a bug, and he was pretty docile, and he was, following all the rules, and he didn't really love it, but he was in a personal care home, and then eventually he got to the point where he could be in his own apartment and was doing well. And then his dad died, I believe. And I don't know that was the trigger, but from that point forward, he became, he was maybe on some substances and was just much more aggressive and grumpy and was refusing meds, like period. That's the end of the story. That's not happening. And he would hide from the program and the whole 9 yards. And so at some point we were able to locate him and get him into the hospital. And he was familiar, he was very smart and he's familiar with the hospital situation enough to know that he knew that the end result was going to be that he was going to have to take the shot, right? He knew that by going to the hospital, that was going to be the end result. So God bless him, he negotiated his way out. Basically, he told the doctor, hey, listen, if you release me today, I'll take the shot today, but it's got to be today. And you know what? That was a win-win. And I was like, well, good for him. And so the doctor agreed, said, yeah, if you take your injection, then we'll release you. And so that was the only time we could get him on meds for months. And so sometimes just something as simple as that worked, where we've been struggling for months. Now,
and how has that one worked out since?
So he's, let me see, he's only been out a few times. So he calls in. He will call into the status conferences, but he won't put himself on video. Right now, we've been doing them remotely. But he still does, it depends. He's about 70-30 showing up and not. So, he's still a struggle, but he's one of our more challenging ones, for sure. But I keep telling him, he's like, I don't want to take the medicine. I don't want to take it. I don't want to take it. And he, right now he's just in a state where he believes he's dead, so he can't take the medicine. So he's got some delusions that are prohibiting, the recovery, but at least we're able to get him at least a shot in him to hopefully marinate a little bit for the next month until we have to do it again. So, but he's, we just try to remind him that we're there to support him and we're there for him. And when he's like, you're not going to put me in the hospital again, I'm like, well, not at the moment. You're still doing well. So, I mean, if you keep coming to these status conferences and doing what you're supposed to do, and we can keep track with where you are, then no. And so, of course, I don't know, it's been a few weeks, and I think I don't recall that he's gone back to the hospital, but I could be wrong. So, every day with him, we cross our fingers. But it was just interesting how he actually took part of that. He negotiated his way out of the hospital, which then made him have to take the medicine, which he'd been fighting for like 6 months. So
To respond to that question from the question and answered list, oftentimes, not often, but routinely, we allow people to negotiate that, take your meds off of their treatment plan in order to get them to agree to accept an AOT order. And then hope that as they enjoy the support of that support team from the treatment providers and their therapy and their one-on-ones and the group activities and the rides and food they get and the housing, that they start, after they've sort of gotten stable with housing and food, they tend to be more open to listening to their therapists. And then the discussion about meds resurfaces. And for the most part, it's worked out, or they've eventually agreed to take meds. I mean, part of my spiel is, I know you had all those bad effects years ago from those meds, but meds have improved since then. And we have that vague discussion. And I asked them to keep an open mind and do their own research and stuff. And that's helped somewhat. But again, there's, like you just pointed out, we've had some recent failures where they're just too stubborn to participate. And even though they signed the order at one point, their stubbornness overcame and we lost them to hospitalizations. But
So there was interesting, we had a case years ago, and this was actually when we call it 1.0, when we tried it years ago. There was a particular case that ended up being successful. She was in extended program, extended AOT, and eventually graduated from the program. But like for the first several months, every time she would come and see me, like every few weeks or every week or whatever it was at the time, she just would cry. She's like, I don't want to take it. I don't want to take it. And she was so upset. And so, several weeks of this happens, and I said, well, I mean, what's the reason? Tell me why you don't want to take the medicine. And she, clarified that it was the injection form, and she was a refugee from, and I can't remember which country now, but the country that was using poison to kill citizens in their country. And so she was scarred from all of that trauma from her country of origin. And so I said, well, treatment team, is she able to get her medicine orally? And will you take it if it's in oral form? And she said, yes. So literally just asking her, I mean, granted, I know that's pretty rare because a lot of times you don't get a straight answer and there's all kinds of other reasons that prohibit it. But for her, it was literally that just somebody said, well, why don't you want to take the injection? But she was willing to take the oral meds. And so literally the next week they changed her to the oral meds. She took them every single day. She got back with her husband. She moved in back in her family with her children, and everything was hunky-dory. And she eventually graduated from the program. It was great. And nobody had bothered to ask her why she didn't like the injection. And so
that's an excellent point, Judge Parsons, because the opposite is also true. I had seen people in our program that once they got on the injection, which was only every 3 months, let's say it was a long-acting injectable, then they basically could kind of go their merry way and not think about the medication, and that ended up working a lot better. So It's really a very individual thing. In Ohio, we have the option under our law of which is how somebody would end up in the hospital, as you already talked about, is filing a motion for forced medication if somebody deteriorates enough that they're that sick that they need to be hospitalized. But we took the issue of medication very seriously, because that starts the road. You know, the road to hell is paved with good intentions. And that our cases started with people that were severely decompensated, very sick in the hospital. They got stabilized, and then their first hearing would be about 3 months. That's again under Ohio law in the court. The only reason we could go that long is because the probate monitor was glued to them from the moment they got out of the hospital, working with the family, getting them a place to live, all of that. So hopefully by the time I saw them for the second time, 3 months later, they were a lot more stabilized and we could carry on a conversation. I would have seen them the first time in the hospital. But that process of making sure that somebody continues with that medication is what prevents the stubbornness, which is really a lack of insight. That's really what it really comes down to. There are a few totally like just stubborn people, but I found most of those had personality disorders. They didn't really have, you know, mental illnesses treatable with psychotropic medication. Most of the people that weren't taking the medication lacked the insight. And you are absolutely right that the process of digging into what is your objection to the medication sometimes, and I found a lot of the time, will get you to a rational reason that you can then deal with.
Yeah. And, you know, to that point, one of the things I love about the story is that it really just speaks to a way the judge can play in such an important role in AOT that isn't really related to the power of the office of the judge. It's just about the fact that you're someone who has a little distance from the situation. You know, an intelligent person with some distance who's just asking some basic questions can very often bring things to the surface that people who are so engaged in it intensely, who are so close to it, can't always see. I mean, the idea that oral medications was all she really needed, in retrospect, it seems so obvious, right? And yet it just took someone with kind of the fresh perspective who's, you know, kind of playing this slightly detached role in trying to make this work, to see those kind of things.
Brian, that's a really good point, because for judges that have not heard these cases and are reluctant because they don't have the medical background or this or that, there's a lot of reasons to kind of be scared, you know, or concerned when you start hearing these cases. One thing that we all are trained in and that we're all very good at, or you wouldn't be on the bench, was listening to facts. That's what we do. We listen to facts. So that same skill that you have of just listening to the facts applies in these civil commitment cases, just like it does in your more evidentiary matters.
Yeah. Yeah, that's a great point. So unless anyone else wanted to say anything else more on this, I'd like to turn the conversation to another important topic that I know is really important to a lot of the people who are tuning in today, and that is how courts can engage families in the recovery of their loved ones. I'm wondering if any of you have had any experience with allowing family members to participate in any way in the court process, to testify at the initial hearing, or take part in the check-ins, and if so, what does that look like? How do, if at all, do you try to involve a person's family if in fact they have some family in the picture who you think can possibly be constructive and helpful?
Well, we allow families any family members in the courtroom, because otherwise our status conferences are closed hearings, one case at a time. We allow family members in the courtroom if the participant agrees to it. So any additional people, it's dependent upon the acceptance of the participant.
Yeah.
Allow them in. And otherwise, the only directive I have is I go to the treatment providers and ask them, what's the update with the family status? And sometimes it's an advocate parent who's opposed to medications or opposed to this or that aspect that is a problem. And sometimes our response to that is finding alternative housing for the participants so they don't live at home for a while. to get that separation. And then I'm relying on the treatment provider for they have an active family outreach that they do, and I rely on their information. But I don't do any other directives from the bench.
Yeah. And when family
I would-
members
I would-
attend those hearings, do they, just one moment, judges. I'm just curious, Judge Anderson, when the family members do attend, if they tend to participate in any way, if you'll ever, ask them any questions or give them a chance to express themselves.
Fortunately, rarely do they seem to want to participate, but I do on occasion ask direct questions if it comes to be important. I know one parent, for example, I started having a discussion that they needed to trust the team and not just themselves, that there's all these other professionals here helping their kid. They need to trust the process and not interfere with it. And that was a difficult conversation we repeated it several weeks in a row, but
Yeah. And that's a good point. Sometimes you got family members who are more part of the problem than the solution.
Yep.
Judge Reese, do you want to chime in?
Yeah, I would say in a substantial number of the cases we've had, family participation has been critical. I mean, and the family members are usually the ones that bear the brunt of all the stressors from the condition of the participant. And they are looking for some kind of resolution, some kind of assistance, and some kind of stabilization so that they are heavily invested. If there is no objection by the participant, I haven't had any yet, to allowing the family members in, then they can sit in the court and be part of the proceedings and even chant in periodically. With the amendment of the statute in this past legislative session, we've made it easier in Louisiana to allow family members to file the petitions for AOT participation by their loved one to get them before the court. And, it's kind of a very ginger process because of HIPAA considerations and all of that. But once we get them in the court, then we can kind of work around that. But the family participation, I think, has been critical in the law. I haven't had a situation where family members, especially parentals, have been at odds with the respondents. So, that's been our experience.
Judge Parsons or Magistrate Hyder, do you want to express anything on that subject?
So we really haven't had too many family members. I'm trying to think if we've even had any family members attend any of the status conferences. I don't recall any off the top of my head. They would be welcome to if they wanted to and the patients allowed it. I think we have maybe seen where we've had more cases where the patients don't want their family members to talk to us at all, right? They're not giving the consent for us to communicate with family. I do remember a few cases maybe early on where family members, we could communicate, we meaning the treatment team or the case managers would, or even some of the court staff would communicate with family, and the family, while they didn't necessarily want to come to the status conferences, used it as sort of like, like you said, Judge Reese said, the family members bear the brunt of a lot of the issues that are happening. And I think that I remember having a few family members that would communicate with the court and say, listen, can you really emphasize X, Y, and Z with my son because, he's doing X, Y, and Z, and I can't deal with that anymore. And so we've sort of became the bad guy for the family, right? To sort of help reinforce whatever it was that they were struggling with, so that they could keep them, in their home or whatever it is they were dealing with. But our biggest struggle, honestly, has been that the patients just don't want anybody to communicate with the family, and we would love to, but we just haven't been given consent for that.
Yeah, so I have a question about that. If you're sensing the situations that the person really would be much better off if they would let their family in, that the family, could play a real constructive role if the person were not so opposed to it. Do you ever kind of use your influence with the person to try and get them to change their mind and grant that access, sign that HIPAA form to let their family members get the information that they're so desperate for?
Yes, and
Stay out of that.
we try. I don't,
Yeah.
I can't remember how successful we've been. I think maybe, once or twice we've convinced somebody to let the case managers talk to family. But, the ones that are pretty clear, but they don't want you to talk to family, they've been pretty consistent. I mean, even though we try and I'm like, okay, might help us, to be able to talk to your mom about blah, blah, blah. No, thank you. So
Right.
that's been our experience so far.
Yeah. One thing I would kind of throw out there as an idea for really any judge who's attending today is there is an exception in the HIPAA privacy rule, for disclosures that are made pursuant to a court order. So, if you come to the conclusion that a person would benefit from having information disclosed to their family, and, there is some legal grounds for the disclosure, you could make that part of the AOT order, that this information shall be shared about how the person is doing, and that the AOT treatment team can communicate with this particular family member. Once that's in the court order, those providers have the cover now of, being squarely within one of the exceptions to the HIPAA privacy rule. They're acting pursuant to a court order. Something that I'm not sure is happening much, but as I read the law, it certainly.
Yeah, we haven't used that in the orders, but that's something to really think about, especially,
Mhm.
I mean, the case managers will take in information, if mom calls and mom wants to tell them X, Y, and Z, they'll listen to the information and then
Right.
transpose it to us. But that's an interesting point. That would be something interesting to bring up to the service provider, see how comfortable they feel about that. I think the service provider tends to get a little nervous when we start talking about, not having consent for everything. But I think that's an interesting point to bring up.
In Ohio, in the initial hearings, all of the civil commitment hearings are confidential. So I think, as some of the judges already mentioned, that if the respondent doesn't want the family member there, then they can't participate in the hearing. And I would not speak to family in the initial hearings or ask them any questions unless the prosecutor called a family member as a witness. That would be the only way that I would listen. In the subsequent hearings, even though those were also of an evidentiary nature, family was at those hearings. I don't have a good feeling for whether it's 50-50, 60-40, I don't have a good feeling, because you've got the segment of family that's really involved, and then the segment of family that's burned out, that doesn't want anything to do with this anymore because they've been dealing with it for years. So one thing I found that I had to be careful of, though, is that if I did want to address family, I didn't ever want it to be interpreted by the respondent, the mentally ill person in my courtroom, that I was turning on them, that I was asking the family a question, that I always wanted to appear as either a neutral party or somebody who was on the side of the respondent, but I certainly never wanted them getting the impression that, kind of behind their back, even though everybody's sitting in the courtroom listening to this, I'm checking in with the family to find out something about them, because that destroys the trust that you're trying to build, and then you got to start all over from scratch. So again, I keep going back to the probate monitor and how critical the probate monitor was in my program. Our program is that I would get a report from the probate monitor, and if there were family issues and dynamics that I needed to know about, they were in that report. So I always had a heads up, and I always had kind of a roadmap as to where I was trying to go with this person, and whether family should be involved or shouldn't be involved.
Yeah, no, thank you. It's a great point that I frankly probably hadn't given enough thought to, the fact that if you perceive your effectiveness is so dependent on the person thinking of you as someone who's on their side, who's, their champion, and they have issues with their family, you could absolutely jeopardize that by seeming to, pick sides, pick the wrong side.
Right.
Yeah.
Road to hell paved with good intentions.
Right. Yeah, it's such a tricky role. It really is.
One of the good things we've discovered is that the concerned families that do come to court, as the persons progress through their treatment and become more and more stable and more independent, they tend to show up less, the other family members. But now they like the situation. They don't feel as compelled to be involved. So it's a freedom thing for them.
Yeah. Yeah, makes sense. Let me just pull a question that's here in the Q&A, and this is from someone who is in New York City, who I know I've had a little contact with already, who in New York City, the AOT model is very different. They don't rely nearly as much on a person's bond with the judge. It's much more about the Department of Mental Health's leveraging of the court order than it is a person kind of feeling that a judge is paying attention to their case. And so she asks, I'll just read it. She says, my brother's psychiatrist through AOT presented to the judge that he's unlikely to take his medication due to his concerns about their side effects, concerns he explicitly expressed to his treatment team, yet no one presented any other options for alternative antipsychotics. They just refilled his meds knowing he wasn't going to take them. He has just been rehospitalized. How should we address this with AOT and the court to ensure that he is heard moving forward? His AOT team is hesitant to releasing any information to us, despite him signing an ROI. So there you have a situation where, it sounds like there's just some barrier between the treatment team and the family, even though there's an ROI in place and there shouldn't be a HIPAA problem with them sharing it. How could a judge be helpful in breaking through some of these frustrations that families may have with their loved one's treatment team? Anyone have any thoughts on that?
I've encountered that before, and part of the treatment order is to set up the medication regimen. And if I get a complaint from the participant, like it makes me too drowsy, or it makes me too sleepy, or some of the other side effects that can occur from a medication, then the question I put to the clinician involved, or a psychiatrist or whomever, is there any other potential medication that could be taken, or does the dosage need to be adjusted? Or because, like we had one person who had a bipolar disorder, and we found that just cutting the medication dosage in half still gave the therapeutic effect and didn't lessen the side effects. And that worked out fairly well. But, when you have the Black Robe effect and a judge involved, you can ask those kind of questions, and hopefully we'll get an answer. Now, and also some accountability, because obviously it's real easy to just write the same prescription over and over. And, you don't have to do any upgrades or updates. But also I've learned that certain medications after a period of time lose their effectiveness, and you may have to adjust the medication regimen with an individual. So that's a question I want to have answered too, is how long have they been on this medication, and what have been the dosages, and what is the effectiveness? And if we're having these effects now, what is the history of it throughout the course of treatment? And if we need to move from this particular medication to another one that potentially may be more effective, why don't we try that and see? And, because a lot of times if you don't at least make those overtures, then the participant will lose faith in the process. And then they'll just say, I'm going to stop taking it altogether. And then you get, the downward spiral. So, that's kind of how we've dealt with it, with past cases.
Yeah. But I think, sadly, just because of the way AOT is different in New York, there may not be that same opportunity there to get the judge involved, just because the judges don't really tend to stay engaged in the cases once the orders are issued.
I think that when I mentioned that, you kind of live and die by your case managers, I think that it's the same goes for your, the entire treatment team, not just the case managers. But if you have doctors that are willing to listen, right, and willing to really look at the side effects and stay on top of them, I think that's critical. And so even if maybe there's nothing that can be done, at least trying something, ultimately, if nothing else can be fixed, but just at least trying it, I think goes a long way for the patient to feel like they're being heard. And so if you have service providers that are willing to listen and attempt what is being requested by the patient and ultimately the court, right? If we're like, okay, well, they're saying that they're dizzy, she's been dizzy for a month, can you adjust it again? And so if you have a doctor that's like, no, I already did it, didn't work, that's it. Well, I can see why the patients get frustrated and just even trying something different. And it's one of the things I ask them every single time I see the person. How are you feeling on your medication? Are you feeling good? Are you okay? Is there something going on? Generally I usually start early on. How are you feeling on your meds, right? You're taking them, how are you feeling? And that way they can tell me, because I always tell them, you can tell me anything you want, doesn't matter, good or bad. And they are like, oh yeah, I'm kind of been dizzy this week. Okay. And then they see me telling the case manager, even though I already know the case manager is already on top of it. But, all right, so case manager, you want to make sure you let the doctor know that. And when do you see the doctor again? Okay, well, make sure you tell the doctor. Okay, make sure you have your appointment on, October 15th. Remember, make sure you tell the doctor that you've been feeling dizzy. Okay, promise me you'll tell the doctor. And then it kind of puts it back on them to really, their self-advocacy, right? To make sure that they have a voice directly to the doctor, that not only did they tell the judge and the case manager is looking into it, but that they need to be part of that as well. And so, so far, I think that's worked. I think 95% of the cases that they've been satisfied with whatever outcome happens, and still willing to work on, okay, look, it helped a little bit, but now I have this other issue. And so they know that it could be just an ongoing tweaking basis. And most of them seem to get that and have been okay with it. Every once in a while, you're going to get somebody who they don't want to take it because they just aren't going to take it. And they don't care. And they're going to, tell you all kinds of reasons why that, they've got all these side effects, et cetera, et cetera. But so far, just having the doctors even just willing to humor us, I think goes a long way. So we've been lucky, I think, there.
I think you'll find if the participant has an attorney, which most should, the family and the participant telling the judge that the provider isn't honoring the ROI could simply result in the court ordering them to comply.
Right.
It's got to go to the judge that way.
Right. But again, unfortunately, I think that's something that's going to be harder to do in New York City, where this particular question comes from, because the judges are just not engaged in the way that you all are in an ongoing basis in the AOT case.
Well, they could file a petition to the court then.
Yeah, right. Right. That's an idea. So in the 10 minutes we have left, one last thing I would hope we could talk about a little bit is how COVID and the fact that court is not live until further notice. I imagine that's still the case where all of you are operating, has impacted the role of the judge and your ability to really bond with people and get to know them in a way that you've described today. And Magistrate Hyder, I'm not sure if you retired from the bench before or after things really changed.
No, I did a lot of hearings on Zoom, a lot of.
Okay. So you have some experience to draw from there. Yeah. I've actually heard some different things from judges I've had conversations with, both positive and negative, about the impact of moving to video hearings. And, some have suggested maybe it's something we ought to continue with some people, even when the world does go back to normal. So I would love to know whatever thoughts any of you might have on that subject, and whether you've been frustrated or seen some good that's come out of, having to see people on Zoom rather than live in your courtroom.
At the outset of our program in 2019, pre-COVID, we went so far as we had hearings at the hospital. And I would load up my court reporter and my law clerk, and we would take a ride over there because it was easier. Didn't have to transport the potential participant because they were about to be discharged. The physician was readily available at the hospital. And the hospital, under the statute, medical director could file the petition. So, we did that just to facilitate getting the process started. Now, obviously, once COVID struck, we had to go to Zoom like the rest of the world did. And let me say that my preference is to obviously have somebody live in court to do a credibility assessment, to get the human contact if you will.
Yeah.
Zoom is 2 dimensions, court is 3 dimensions. You get to see the 360 of the individual and make the credibility assessments of them and the other participants, the other stakeholders. That's definitely my preference. Now, reality being what it is, Zoom has its benefits for convenience. We don't have to worry about transportation issues, et cetera. And we don't have to worry about the person showing up because they're right there. So now when they get home, a lot of households aren't equipped to have Zoom hearings. So that becomes an issue. So, but, potentially the ACT teams can help facilitate that or whatever. But, it provides, it has its ups and downs. It's, 6 one way, half a dozen another, I guess. Easiest way to say it.
Interesting. Yeah. And I think that is what most of the programs that we have been talking to tell us, is that rather than just rely on a person to, keep an appointment and sign in on their cell phone at a certain time, they're actually sending the case manager to the person's home with a device in hand, a tablet in hand, but they'll get the person logged on and make it happen. Any of our other judges want to share their perspective on this question? Anyone have any strong opinions on it?
Well, we've gone back to live hearings if the participant wants to come to court or is willing to come to court. We still have occasional video appearances by team members, providers, or even county counsel.
Yeah.
We're a small county, so it's a little bit easier. The public defender is always in person. And that's helpful. But
yeah,
it's case by case. In the future, there's occasionally some folks that are going to feel better by not coming to court. So we'll have them appear by Zoom.
Yeah. Do you have a preference, Judge Anderson, of whether between seeing people in person or not?
I'm old school. I think that I like them being in person. I like witnesses and evidentiary hearings to be in person.
Yeah.
So, yeah.
So the benefit that I found with Zoom is interesting, which was unexpected, which I think our participation has gone up significantly if you compare it, because Harris County, we're huge. We're a huge county. So it can take an hour or 2 hours to get from one place to another. And especially if you've got transportation issues and, people get grumpy and they're gone all day and then they got to wait for somebody else. And it's just where the participation, because they're in their own space, right? And they can just call in. And then also if they're grumpy about where they're living, they can show me. I get to see where they're living. I get to see what the issue is, right?
Right.
So that's a big a benefit. But I think once we're able to kind of really go back in person, I wouldn't mind kind of maybe staggering the experience, right? Having them come in person every so many months, but Zoom otherwise, whatever works for that patient the best. And I think it depends on the downside of it is that they're more easily able to disappear, right? If they don't want to listen to what I'm saying, they just get out of that Zoom call and they're gone, right?
Right. You don't know what they're looking at on their screen, right?
Yeah. So, there are benefits. I really can see the benefit of having Zoom part of the status conferences going forward. But yes, I think in person, especially at first, I feel like in person would be important to resume.
Yeah. I mean, I would think just from what I know about Harris County, just how difficult it is to get around, how vast it is in terms of territory and how bad the traffic can be, that just
the numbers that we have now, I mean, the case managers haven't said anything, we haven't talked about it, but I know I can just feel, if I was a case manager, I would dread having to come back in person.
Right.
You have to wrangle all these people and put it, it would just, they're already having to, spread out case managers so that they're there with the phone if the person isn't not able to work it on their own, or, because they're there to make sure they've got a tablet or an iPhone or something if they don't have one. And then they provide them one if they're able to use it. So it's already a lot for them as it is. I can only imagine that they're probably dreading in person when it happens. So I would be thrilled to just stagger it and use both going forward.
Yeah, makes sense. Magistrate Hyder, how did you feel about that transition when you experienced it?
Well, in March of 2020, Butler County Probate Court literally went from live to remote within a matter of days. I mean, it was just days. So, I found myself at home in my home office where fortunately I had really good equipment, learning, watching YouTube videos on the weekend and whatnot, and trying to get up to speed and all of this. And I ultimately ended up serving on our Supreme Court committee that put together for the justices a number of recommendations about how Ohio goes forward with this in the future. And I think initially what I ended up finding is I was surprised at how well it worked, how receptive people were to it. And a lot of it at that time I attributed to, and I think I was right, is how hungry we all were for human contact. This was also during the lockdown periods. And just to be able to see somebody and talk to them and check in like you did in the old days felt so good for me and for them. As time went on, it starts to wear on you. I find myself going through another cycle now that I'm kind of warming back up to the video thing. It's like I started getting burned out on it, and then after a while you start to warm back up to it. And I'm not doing hearings anymore. I haven't been doing hearings since last November, but I think I agree with Judge Reese. It's kind of 6 of one, half a dozen of the other. And as Judge Parsons said, there are certain individuals where this mode of communication with the court really is preferable. If they don't want to come to the courtroom can be a stressful place. And there's also there's a certain kind of, I was on a committee with a judge that was a domestic relations judge, and she did divorces. And we were talking about our experiences with these remote hearings. And she said that people come in, do you have anything to say? Nobody wants to say anything. They're kind of giving the side eyeball to their ex-spouse or soon to be ex-spouse. They just want to get out of there. And she said she's had more people talk to her and more spouses talk to each other on the remote than she's ever seen in her entire career.
That's amazing.
It is. There's something intimate about this, but yet you still have your kind of elevator room around you, or whatever it is you want to think of it as. And I think in certain cases with certain respondents, this medium lends itself to more communication with them, with that type of individual versus less. So
you have that quick escape button.
Maybe that's it. Yeah, maybe that's it.
Yeah, that's fascinating. Thank you all so much for your insights on that. And this has been a really illuminating 90 minutes for me. I've enjoyed it. I've learned some things, and I hope everyone who's listening in did as well. I thank you, judges, so much for your time and taking part in this and sharing your experiences. And we'll continue to all stay in contact. The Learning Network is all about networking and communication. So if any of you feel a need to continue this dialogue, please get in touch with us. We'd love to facilitate conversations with any of the judges who took part today. And thanks again, everyone.